I'll go on now to the first presentation. And if Mr. Shomade would allow me to share my screen. Thank you very much. So, thank you. Now, the Lagos Settlement Week 2021 program. What is it all about? I'm going to give you the content. Okay. So we're going to go through the mission of the Lagos Settlement Week, just a little bit of history, the enabling law of the Settlement Week, goal and objectives, the Settlement Week forms, the documents, how do you become eligible to participate in the Settlement Week, referral guidelines, mediation itself, just to have an idea of what mediation is, the role of counsel, the role of parties, that's the expected role of counsel and parties during mediation, the statistics to see what has been done before, whether the Settlement Week is actually, decongesting the courts as expected, and then what are the challenges we face, and then we'll conclude. So the Lagos Settlement Week is defined in the LMDC law 2015 laws of Lagos State, and section 40 of the Lagos Multi-Door Courthouse law says that the Lagos Settlement Week is a week that is set aside by the Honorable Chief Judge of Lagos State for specific courts, high courts, magistrate courts, to clear the backlog of cases. Means which include return to the LMDC for the possible resolution through mediation, arbitration, neutral evaluation, any other area procedure, referral, to the LMDC. So what that means is that the Honorable Chief Judge will select courts, high courts, maybe by a memo, tell them to refer cases to the Settlement Week. So what the judges will do is to refer to the referral guidelines that are with them. And those referral guidelines, they will use it to screen cases. The case managers of the Lagos Multi-Door Courthouse will also go into the courts, into the court docket, and screen cases that are suitable, and then send those cases to mediation through the Settlement Week. So just a little bit of background. The first Lagos Settlement Week was actually organized in 2009, and it was organized at the High Court of Lagos State, Iposhiri. I think there were about 84, 86 cases that were mediated, and about 46, 47% of those cases were settled. So this was recognized by the Center for Effective Dispute Resolution in the UK, and that settlement with the first one ever organized actually won the Significant Achievement in the Field of Dispute Resolution Award during the 20th anniversary award ceremony in London in October 2010. So just to let you know that even the international community is watching. Now, the enabling law is section 3, subsection 1 of the LMDC law 2015 laws of Lagos State, which says in section 3, subsection 8, that the LMDC is empowered to promote or undertake projects or other activities, including but not limited to the Settlement Week, which in the opinion of the council will further assist in decongesting the courts and help to achieve the purpose for which the LMDC is established. So this actually speaks to the fact that essentially one of the major objectives of the Settlement Week is actually to decongest the courts. And the primary objectives of the Settlement Week, reduction of caseload of the courts, and that's the congestion. Secondly, speedy resolution of disputes. Some cases have been in the courts for quite some time, 5 years, even to 10 years. So speedy resolution of those disputes. Settlement week parties sit down at a table together and have the opportunity we find out that whatever agreement that comes out of it is satisfying because the parties agreed themselves. And timely means it's cost, it's in a speedy way, and then of course it is cost effective. So the goal of this particular settlement week is to resolve at least 80% of the cases referred to the program. The reason why we say 80%, in the past 10, 11 years that the settlement week has started, the average settlement rate has been 50%. So we want to take it to the next scale. We try our best this particular 2021 and ensure that we get at least 80% of the cases settled. And we can only do that with all stakeholders. So what are the arguments that you expect to get? Now, if the court should say, refer your matter to the settlement week, there is what we call the enrollment of order form. The judge will sign the enrollment order form, signifying that that case has been referred to the settlement week. Now, what is expected of parties when they is to complete what we call the submission form, that is submission to alternative dispute resolution at the settlement week. Now, just before the mediation, you'll be expected to fill attendance sheets, the agreement to mediation. There's an agreement that shows that you have voluntarily you've come to mediation. There's a confidentiality agreement that says that you agree to make everything here in the mediation session to agree for you to be confidential. Then, of course, there's the mediator evaluation form, which allows you to be able to give a feedback to the mediator. And then, of course, the terms of settlement. If the matter settles, then you'll be expected to sign terms of settlement. Now, which cases are actually eligible for the settlement week? All pending civil cases and working matters, covering a wide range of disputes. And we're going to look very soon, we're going to look at the kind of subject matter cases that are eligible for the settlement week. And then they can be nominated either by the order of the court. The judge can say this matter is suitable for settlement week and refer the matter to settlement week, or the parties themselves can agree to submit to the legal settlement week. And of course, we also have working matters where parties can just agree to come to the settlement week and they're actually not in court. So the kind of cases that are expected, that are suitable for the legal settlement, are commercial contracts, construction, banking and finance cases, workplace, industrial relation cases, intellectual property, insurance, matrimonial and probate, real estate and tenancy. Those are the cases that are suitable, right? Okay. So we'll look at mediation because it's important to have a sense of what mediation is, going forward. So mediation is actually a effective process that is conducted confidentially, in which a neutral person actively assists parties in working towards a negotiated agreement of a dispute, with the parties in ultimate control of the decision to settle and the terms of the resolution. So if you look at this definition, the flexible process means, it's a voluntary process, really. nobody is mandated to come. You come willingly because you are interested in having your matter settled through mediation. And then it's a confident. Well, let's look at it one by one. What does voluntary mean? Parties' participation in the process is voluntary, and the decisions made during the mediation are voluntary and entered into freely, so that nobody is coerced during mediation. They take ownership of the process. They're committed to the process, they're empowered, and of course, the agreements are successful. Secondly, informs consent. The parties choose to participate in this mediation after having been informed about the process. And that is why at the multi-door, we have what we call the memorandum to parties that gives them information about what mediation is, so that they want now to participate in that process. So informed consent means they're empowered, they understand, they have the knowledge of what mediation is, and they will sit down and negotiate workable and valid agreements because they understand what they're going into. Now, the self-determination assumes that the parties, if given structure and support by a mediator, have the ability to resolve their own disputes and determine the options that best work for them. So the mediator actually empowers the parties to understand and to know that they can, resolve this. They can sit down and negotiate and resolve themselves. So empowerment is there. The parties take ownership, and there are workable agreements because the parties themselves are the ones. Of course, they're committed to solutions. So, again, would you see any parties in need of the agreements? Because they're committed to the solution. Right? Now, neutrality. Important to note that mediators they have no and they bias in engage. To know that the mediators are actually they are neutral. They don't have anything the subject. So what this does, neutrality, what it is that, it will make the process Mr. Shomade or Rosemary. Now, if parties know that it is a neutral party, we have been building trust in them. Neither the party feels judged, neither of the parties feels that the mediator is judging them, and neither of them feels blame to action and solution. And of course, lastly is confidentiality. It is important to know that all information that is received in mediation is unless agreed upon in advance. If the exceptions to the confidentiality rules. In the private session. Please, Mr. Tomade, please help to mute. If you are not talking, can you please mute your microphone? Mr. Israel Matesu. Mr. Israel Matesu, please mute your mic. Thank you. So, confidentiality, it encourages openness for discussion between the parties and the mediator. Now, the parties, when they know that even if you take them to a private session, if the mediator assures them that this is a confidential process. Whatever it is that you tell me, I will not tell the other party. Then they will be able to accept responsibility. They'll be able to tell you the truth. They'll be able to open up and say, oh, this is the fact. This is actually what happened. And they don't have to say it in front of the other party. And they know that the mediator will not share it. So this kind of safe environment actually encourages solutions, encourages the parties to move towards resolution of the dispute. And of course, it's conducted entirely without prejudice. So what are the phases of mediation? The first is preparation. If we do not prepare, one is definitely preparing to fail. Now, preparation is not only on the part of the mediator. Preparation is also on the part of the parties and their counsel. And preparation on the part of parties and counsel means that the parties and counsel, they have spoken, that is, you've spoken to your lawyer. You know, if you're a party, or if you're a lawyer, you ensure that your party, whether it's an organization or an individual or a public sector organization, whatever, ensure that you have very comprehensive discussions with your clients before you come to mediation, so that you understand from your client's point of view and you can advise your client accordingly. You also ensure that all relevant documentation that might be required, maybe land documents, maybe some agreements between your client and somebody else, just ensure that all documentation, you have it ready with you. So that during mediation process, when the mediator is asking, you can quickly offer such documentation. So you've spoken to your clients, you understand your client's point of view, you understand your client's partner, the best alternative to a negotiated agreement, you understand your client's partner as a solicitor, and then as a lawyer as well, you understand your own role. You make sure you prepare your own role as a solicitor. We will go on when we soon get to role of lawyers. So from the preparation, you have the opening phase. And the opening phase is where the mediator meets with the parties and their lawyers, most likely for the first time. So the mediator gives an opening statement and explains to the parties what mediation is, the principles of mediation. He even tells them what are the ground rules during this mediation. Things like you don't, your phones, it's better to put them off or put them on silent, things like that. You don't use abusive language, you don't interrupt each other and all that. Now, from the opening, you have what we call the exploration phase. The exploration phase here is when the mediator invites the parties to caucus sessions, private sessions. So in the private sessions, the mediator has the opportunity to be able to probe and ask open questions from the parties. Ask them, so that they can open up to him and he can understand and get to the underlying interest of the parties. Now, from exploration, we go into bargaining or negotiation, where by the time the mediation gets to the negotiation stage, it means that from exploration, going back and forth between the parties, the mediator has seen common ground, areas of common ground between the parties. And he has seen pockets of agreement, so that it is now ripe for bargaining. And bargaining back and forth to be able to get to a situation with a position between the parties where he can say this is what each of the parties want before he now gets to conclusion. Now, from conclusion, if there are some areas that are not clear, you can still go back to negotiate further. And even in negotiation, if you see that there are areas that are still not clear, maybe the agreement is not workable or things, they can now go back to exploration. So from concluding, sometimes you need to go back to negotiation. From negotiation, sometimes you need to go back to exploration, just to ensure that you have a sound and workable agreement, at the concluding stage. So what is exactly the role of lawyers in mediation? Section 24 LMDC Laws of Lagos State 2015 says that the responsibility of counsel in regard to ADR is to the court that referred the matter there, if it was a referral from the court, then the Lagos Multi-Do, and then the legal profession itself in promoting a better and more efficient justice delivery system. Now, you don't agree with me that encouraging alternative dispute resolution actually promotes a better and a more efficient justice delivery system. When we get to, you will see what contribution that alternative dispute resolution has made to the justice system. Counsel also has a duty to expose clients to ADR, to explore with them the most appropriate mechanism in the resolution of matters brought before them. So what this means is that as counsel, you should expose your clients to other ways. It is responsibility as counsel to be able to say it is not only litigation that is happening. Able as a dispute as a lawyer to understand the various dispute resolution processes that are available. You cannot be a 21st century lawyer and the only thing you know is litigation. You must be an all-round lawyer and understand the different mechanisms, of alternative dispute resolution. So when we've gotten to that past that stage, counsel, when they receive an order or a directive from the court that this matter should go to settlement in Lagos Multi-Do for mediation, what is your role as counsel in that regard? You should give due consideration and support to all the suggestions, orders, and directives from the courts for an amicable resettlement of the dispute or the referral of ongoing matters to the Lagos Multi-Do. You should give regard and ensure that clients accord respect to notices, invitations, and directives from the LMDC, so that when your clients receive a notice of referral from Lagos Multi-Do or something, as a lawyer, your responsibility is to encourage him and explain to him that it is important that he attends the dispute resolution session at the Multi-Do. You should respect the notices, respect the invitation, and go there. And then lastly, you should further the course of ADR and give effect to the overriding objectives of the LMDC. One of the major overriding objectives of the LMDC is to decongest the courts of cases so that there will be timely resolution of disputes. If, as a lawyer, you do not further the course of ADR and give effect, you are actually helping to clog the judicial system. As lawyers, we should be ambassadors of ADR. We should be helped to further the course of ADR and give effect to the overriding objectives. Now, what about parties? What is the role of parties in mediation? They also have a responsibility to the LMDC, to the Lagos Multi-Do, and to the ADR process. And they are to cooperate with officers of the LMDC in the administration of their disputes. So that when they, they get in touch with them, they should cooperate. They shall consider the possibility of ADR procedures for resolving their claims or their issues when encouraged to do so by the court or their counsel or even the LMDC. So if the court refers your case to LMDC, refers it to ADR, or your lawyer advises you to go to ADR, as a party, your duty is to consider it seriously and to obey. At least just go and see what the benefits of mediation are. As a party, you should initiate the resolution of any ongoing dispute to ADR and have due regard to notices and directives from the LMDC. So even as party, you are the party that was, even as a party, you should initiate the resolution to ADR. You should say, why don't we go to ADR? Why don't we, instead of staying in the court? And then for alternative dispute resolution as a party, you must ensure personal attendance at the ADR session. Because mediation is a party participatory process. It's not, like the courts, where it is only your lawyer that can speak books and things like that. Mediation is an informal process. The personal attendance of the party itself is needed, is required at the ADR session. And when the party is a corporation or a body, or maybe an organization, a public sector organization or something, they must ensure the attendance of a suitable high-ranking official with authority to settle the dispute on behalf of the corporation or body. So what we are saying is that if the party is a corporation, or the corporation in the organization in the public sector, or the private sector, or just an institution, a high-ranking official that is well seized of the facts of the case, that has the authority to sign the terms of settlement on behalf of that institution, that has full authority to negotiate on behalf of that institution, should be the person attending that mediation. We cannot afford to have a corporation who is represented by somebody who doesn't even have an idea of what the case is all about. And then parties are to attend the ADR session in good faith, without undue request for adjournment. They should not assume that they're in the court, and that the way they just adjourn matters in the court, they are free to do so in ADR. You should attend in good faith, instead of requesting for adjournment. We've had so many cases. People will send the mediation is scheduled for 10 o'clock in the morning, maybe on the 2nd of April. That 2nd of April, around 9:30, quarter to 10, about 10 o'clock, the time of the mediation, you see lawyers calling and saying, my client is sick, my client went to London, my client is not available, at last minute. Meanwhile, the other party would have arrived. And that is why in the practice direction, the mediation, LMDC practice direction for mediation procedure, it is written there that it is stated you need to give at least 48 hours notice if you are not going to be available at an already scheduled mediation session. And then, of course, prepare adequately. We've talked about preparation. It is important as a party you prepare yourself. And then be actively involved. Be willing to explore various options towards settlement. If this is not possible, can we try this? Can we look at this? Can we look at that? It's important. Be actively, participate actively. And then, of course, that sort of thing, you'll be able to see, get a resolution. Both parties cooperate and are willing to resolve the dispute. Okay? So let's look at statistics now. This time-bound mediation, because the settlement with mediation is time-bound. We schedule 9 to 12 sessions, 3 hours, and then 1 to 4, another 3 hours. So we have morning sessions, we have afternoon sessions. And so far, what's the statistics saying? We have statistics from 2009 when it started to 2020, which is last year. 2020, unfortunately, was a very good year. Let me put good in quotes. So if you look at the bottom and look at the percentage of the percentage rate for the settlement rate, you will see that it's hovering between 47. At the end of the day, the average settlement rate is about 50%. So if you look at the second to the last, you will see, the cases that were fully settled, the number of cases. So we've had about 300 cases that have been settled through the settlement week. We have some cases, some years like 2018, 2016, where we had 680 cases, 74 cases, 493 in 2019, some really large figures, which shows, as far as we are concerned, that lawyers are embracing as a method, a technique of dispute resolution. And we hope that this will continue, because removing 3,004 cases, it means that these 3,004 cases, the judge endorsed these cases as constant judgment in the High Court of Lagos. And we say the constant, it can be enforced as a judgment of the court. So removing this number of cases, as far as we are concerned, is not enough. We have just started. 3,204 cases is not enough. So that's why we are appealing that with all we have said concerning the role of counsel, role of parties, and what is expected as a party or counsel in mediation, and your full cooperation, that will be able to move from 50% settlement rate to 80%. Now let's look at some of the success stories of the Lagos Settlement Week. Within the past 5 years, 37.6 billion speedy recovery in monetary claims. That is, we've helped, and this of course helps the economy of Lagos State as well. If you have helped parties to recover about over 36.6 billion in claims. A land case that has been in court for about 38 years was resolved in one mediation sitting. So that's what when we say it is a timely way to resolve, that's what we mean. If a case that has been sitting in court for 38 years, it came to mediation, only one mediation sitting, they have resolved. They have taken it back to court, they have entered it as consent judgment. The 38 years, I don't know what it is. In just one mediation sitting, they resolve. Because they had the opportunity to sit across each other and talk to each other face to face. They had the opportunity to speak, to be open, to say what they wanted. They could talk to the mediator in private and say, reveal this one to him, don't tell him this one, disclose this one, but this is how I feel about this matter. Just one mediation sitting, and 6 other land cases for way over 10 years were also resolved at that stage. And we're talking of land cases here that will be in court for years. Administration of estate case, people fighting over inheritance. It's been in court for about 29 years, you can imagine. It was resolved in 2 mediation sittings at the LSW 2018 program. That's what we mean timely. Those are the benefits, those are the gains of mediation. It's been in court for 29 years. They came to mediation at the settlement week. Within 2 sittings, they have resolved it. And they've taken it back to court, it has been entered as consent judgment. You can imagine if there was no settlement with no motive, they will still be there. 5 cases for dissolution of marriage were settled, and the spouses withdrew their petition and continued their cases in court at the LSW program. In fact, there's a particular one that I mediated personally. Both of them had not spoken to each other for years. They came just because to share property and to get custody of the children. You could see, feel the malice between them. They were not talking. When I saw I was not getting anywhere, I said they should excuse me. I got up. I said they should just excuse me, both of them. I told the lawyers to come with me. I removed the lawyers. We left the place. He said, we're going to give you some 10 minutes. The woman was shouting, I don't have anything to say to him. Why are you leaving me alone with this man? I said, don't worry, just stay here for 10 minutes. We'll come back. I carried the lawyers with me out. She said she has nothing to say. I just said, just stay here, stay for about 10 minutes. We'll come back in 10 minutes. I took the lawyers, we went out. 5 minutes, luckily there was a window there, a very high window. So we could go and peep and look at them. We went to people, they were talking. On that 10 minutes, we went to people, they were talking seriously, animatedly. They were really talking to each other. 15 minutes, after 20 minutes, we had to go back. Ladies and gentlemen, you will not believe, both of them, they cancelled the divorce proceedings in court. They said there's no need, they want to go back. The lawyer was asking me, what did I do to them? I said, you can see it, I did nothing. All I did was to leave the room and ask the lawyers to leave the room, giving them the opportunity to talk to each other. That is all. It's as if they were catching up on old, things, maybe the children, their progress, and whatever it is that made them. They went back together. A banking case of which a claim of over 1.6 billion, with a claim of over 1.6 billion, was settled in 2 mediation sittings at the settlement week. It has been in court for years. We are talking of 1.6 billion here. In 2 mediation sittings, it was resolved. So these are the kind of things that encourage us to say, look, we have to continue. From where we are coming from in 2009, where we had only 37 cases, 2010, 30 cases, and it was rising gradually. We know that people, lawyers, they are gradually embracing alternative dispute resolution. But there is no program that doesn't have its challenges. So, when they're in court, for example, and the lawyer says, the court says that the matter should be referred, sometimes the court registrars, maybe they don't understand. Or maybe they don't give enough cases. They don't look, at the dockets, and they do not give enough cases. Also, lawyers, you wouldn't believe that there are still a lot of lawyers that do not submit to ADR. Once the courts ask them to go and submit to mediation, they refuse. And even when they come to mediation, they'll start telling you that the only reason why they are here is because the judge told them to come. They have no interest in mediation. And in this 21st century, to still have lawyers that do not believe in ADR is so sad. The attitude of the parties, and that's why it said parties should mediate in good faith. They shouldn't call at the time the mediation is about to start and say, oh, they are sorry, they are not available. They are sorry, they are sick. Sorry, there is traffic. Sorry, giving all kinds of excuses for reasons best known to them. And then sometimes parties, they dig into positions. They have this attitude of positional bargaining. No matter what the other party says, no matter what the mediator says, they are recalcitrant, they refuse, they say they are not going to agree. So that's the attitude of parties. Those are one of the major things that lower the settlement rate. Even lack of understanding of the mediation process. And you see, if you don't understand the mediation process, you won't want to submit to it because you don't understand what they are doing there. That's why we try our best to empower and sensitize people. We tell people about what mediation is all about. If they do not understand, they will not want to participate. Even lack of sufficient preparation by lawyers. You see lawyers, they don't bring any documents. They don't even talk to their clients. You get a situation where, clients attend mediation session from corporations, big corporations. And you ask him, so what? I say he doesn't know anything. They just asked me to come. My company told me to come. He's not well seized of the facts, doesn't know anything about the matter. And they told him to come and appear in mediation. What is he going to say? Because one of the major aspects of the opening of this is for the mediator to hear from the parties and tell me what happened. So if the lawyers don't prepare their parties, there's a problem. Absence of authority at the mediation table. You won't believe parties, they come, they don't have any authority to sign. And they come to the mediation and even get to the stage where they sign the agreement, and then they say that they are not authorized to sign anything. So that is why you see mediators always request for a letter of authority from their company or the organization before, allowing them to even represent that organization at all. So despite the sensitization that it is only people that are well seized of the facts, people that have authority of the organization to sign, to take decisions, to negotiate on behalf of it, those are the people that should be at the mediation table. We still have that challenge where they just send anybody, somebody who doesn't even know anything about that particular case, they send him to come to mediation. The mediator will be asking, so what happened? He doesn't know. And he's representing the organization. So that's a major challenge for us. And then the inability to get contact details of parties. If we don't have their contact details, there's no way we are going to be able to get in touch with them. So when the courts refer, or even when individuals working, we always try and tell the individual, you need to give us the contact details of the other person. It is important. Otherwise, it means we will not have a full submission. We just get what we call partial submission. Only one party has submitted. Even in the court, when the court refers them, only one party. You see only one party has submitted, we call it partial submission. The other party, we don't even know his country, we don't even know his address, we don't know his phone number. So that's why we always tell the submitting party to, as much as possible, go and try and get the contact details of the other party. And then change of counsel. You see where parties, They change their counsel as if they're changing clothes, their clothes. One mediation session, and the second one on that counsel is representing them. The third session on that one is coming. By the fourth one, when the case manager calls to say, okay, the mediation is scheduled for so and so, the counsel say, I'm no longer representing the client. Who is the new counsel? He will say he doesn't know. It's a problem for the case manager. They do not have just one counsel for the period of the mediation. So that is also one of the major challenges that we face. Now, if all these challenges can be surmounted, the settlement rate will definitely look better. We'll not be looking at 50%, we'll be looking at 95%, we'll be looking at 98%. We'll even be looking at 100% settlement rate. If we can overcome the submission of lawyers to mediation, attitude of the parties, recalcitrant parties that are not even interested and not willing to have a resolution. I've never seen this sort of thing where people invite you to a place where you can resolve your dispute and you are recalcitrant, you are not interested in resolving. Some people just want to stay in court for years for reasons best known to them. So understanding of the mediation, and that's why we hold workshops, seminars to sensitize people about what mediation. It cannot be emphasized, it can never be much. We tell people preparation by lawyers, we even hold mediation advocacy training, that is training lawyers how to represent clients in mediation, so that they don't have that adversarial litigation psyche, but change it to a non-adversarial one. And this is the law, this is what the law says, this is my right, and start looking at interest-based bargaining. Those are the kind of things that will help us to get to the 100% settlement rate. So we're counting on the all stakeholders, everybody, counsel, parties, everybody, counting on your cooperation to make the settlement rate a great success. And we believe that it will be so. We will take questions at the end of the Deputy Director's presentation. Thank you very much.
Thank you very much, Ma, for that enlightening presentation. I also want to let us know that the Lagos Settlement Week program is still ongoing, and we are still entertaining matters. So counsel can refer cases to the Lagos Multi-Door Courthouse for the Lagos Settlement Week program. I would like to introduce Mrs. Achereko, the Deputy Director of the Lagos Multi-Door Courthouse. She'll be taking us in getting the best out of mediation, preparing for time-bound mediation, representing your client during time-bound mediation, how to negotiate the best outcome for your client, and concluding settlement. Mrs. Achereko, thank you very much, Ma.
Thank you very much, Rosie, and thanks to the director. It's a pleasure to be here. Thank you to everyone, Director, Civil Litigation, MOJ, Deputy Director, Civil Litigation, MOJ, and thanks to everyone who's been able to make it here today. So we've listened to the Director of the Lagos Multi-Door Courthouse giving us an entire framework on why it is important to refer your matter to the Settlement Week program. So now we're going to look at how do you get the best out of mediation? We know it's good to refer your matter to mediation, but now how do you get the best out of it? First of all, let's look at the outline. Mediation has phases. I'm sure we've seen that already. But let's structure how to work towards actually getting to settlement at the end of the day. So before mediation, what should you do? During mediation, what should you do? And then when you're concluding settlement, what should you do also? So that's what we're going to be looking at. Now, before mediation, simple things that you need to do: contact the LMDC. And then when you contact the LMDC, what is it that is required? Let us really note these things. They're simple in nature, but absolutely crucial to achieving settlement. So these are your tools that you're going to see going forward. Documents, the most basic, or items to be brought to the mediation should be provided in advance. What documents do you need? So in essence, you're not really trying to prove your case, so to speak, but the mediator will need to see certain, if you have certain allegations or certain claims, what documents are you bringing to say there was this contract, there was this invoice? So it's important to have those things with you, even if you've concluded in court, just come with all the documents to the settlement week program. And then also timing and venue issues, call ahead. Every case has a case manager. So you don't need to be worried at all. You just call your case manager and ask, what time is my matter ready? Is it for the 9 to 12 or the 1 to 4? And then where's the venue? You realize that we have 2 venues. So your matter could hold at Tafawa Balewa Square, which, the High Court there, in any of the courtrooms which we've been given permission to use, or you could have your matter at the High Court of Lagos, Ikeja. So you could go to any of those places, but confirm from your case manager where your own case is holding, and identify additional parties. Sometimes the parties that are on the claim, in the pleadings, they are not the only parties that you need. You already know who you need to bring to the mediation. Discuss these things before remember we're discussing before the mediation starts. You need to discuss with your case manager to see, I've observed that it will be important to allow so and so person speak. Now the case manager will get through to the mediator and say, oh, look, can the party bring in this additional parties? If you're a corporation or a government entity, clarify the requirements for authority to settle. So we are aware that there's some instances where there's nothing you can do. You have to come and represent your organization. But what we ask is, ultimately, who can you call at that table? So like director has said, we're not really anticipating adjournments where they are unnecessary. So you find that per case, you might not have more than 1 extra or 2 extra dates being taken within a very short time frame. Now you don't even have to take that time frame. You saw the statistics in terms of success stories, that some cases settle in a day. Many actually settle in a day. So if you confirm before you come, who has authority to settle? If that person cannot be there, at least the person who is coming should be seized of the facts of the case and can reach out to somebody who can authorize settlement. And then if that person is to sign, they can only just take the document to that person, but preferably anyone who has authority to settle should be at the table if we're really ready to run to a settlement. Now, special needs or circumstances, elderly, people who are ill. So the courts on different floors, for instance, here in TPS. So just let the case manager know what your special needs might be. And as much as we can accommodate it, we will accommodate it. And of course, discuss any concerns you have. It is mediation. You can speak about it. Any concern you have whatsoever, discuss it before the session actually starts. Secondly, so that was about contacting the LMDC. We just talked about things you can do when you contact the LMDC, things you should reach out to us for, in the first phase. Now let's look at preparing your client and yourself. Now, very importantly, you need to understand what the mediation, can we mute please, if we don't mind, or Mr. Shumade, can you mute everyone so that we can all get the benefit of the conversation we're having? Okay, so now, how do you prepare yourself, or how do you prepare your clients? In preparing yourself for your clients, you need to first of all understand what is the nature of mediation. What can I do, what can I not do? It is a participatory process. You've listened to all of that in the director's presentation. So now you need to take this information you have to your clients. You need to further internalize what you have learned. It is a confidential process. It is party-driven. So the mediator is going to be leaning on you. Can we kindly mute? Is it possible to mute everyone so we can move on smoothly, please. Thank you, Mr. Shumade or Rosemary. Thank you. Okay. This is quite noisy. Okay, has stopped. Thank you. So now to prepare your clients, what you need to do, understand the process, coach your client on how to give a summary. So you see, there's an opening phase where your client will be requested to give a summary of the case. So your client needs to know how to give a summary. Just a brief intro. Your client will have another opportunity when you go into a private meeting to discuss your case even further. So at the opening phase, it's just a summary. So discuss that summary with your client before you come in, and it's the client that gives the summary. Then discuss what is most important to your client. Interest versus your client's position. What is most important? We will look at that further to understand the difference between an interest and a position. And then finally, if you are external counsel who is listening here today, present your bill for the mediation session. What is your bill? Now, the reason why we say this, and this is part of preparing yourself, is such that you don't wait until you come to mediation and then you suddenly realize that the case is over in one day. And all the money you thought you could get if you were pursuing it on a trial basis in court, you can no longer get it. So before you get to the mediation table, be your client. Say, if we settle in one day, this is how much you're going to pay me. So what that does for you is that you do not find yourself in a situation whereby in negotiations, because you have placed your billing on the percentage of the outcome of the case, you will probably fight against resolution. And I say this from experience. We have cases in which the mediator, because the way mediation is, it is party driven. So at the beginning, the mediator can decide, look, I want to speak with only the parties. I want to speak with only the lawyers. I want to speak with only one lawyer. It's dynamic. So you don't want a situation where the mediator has to caucus you for the sole purpose of negotiating with you or negotiating your fees, because you don't want to settle because you have calculated 5% of 100 million as your fees. And then the party says, in fact, imagine a defamation matter. In fact, that 100 million, I don't even want 100 million anymore. What I want is an apology, because that is your party's real interest. What then happens if your fee is solely based on 5% of 100 million or 5% of 20 million? How do you get your money back? So this is why we say, if you are external counsel in the room today, present your bill, a mediation bill. So let's look into doing that before the mediation actually starts. Now, I said we'll talk about positions versus interests. What is a position? What is an interest? Very simply, positions are the things that the parties will look at the next slide and define the positions adequately. But let's look at this iceberg first of all. If you look at the wavy line, that is an ocean. And the big rock you see there is an iceberg. Now, the iceberg typically can run a ship aground because the captain of the ship might not see the larger interests beneath the sea, because the iceberg, normally you hear is saying that it's only a tip of the iceberg. So the positions are like the tip of the iceberg. Meanwhile, the interests which run the ship aground are what lie beneath. And that is what the mediator is going to spend time trying to find out, so that parties can satisfy their various interests. But before the mediator begins to do that during mediation, the client and the counsel should speak with one another and find out, what are my real interests? What really are my real interests? You see, he's saying, if he'd only look down here, he will find out what my real interest is. Your client expects this of you. So if you have never done this before, in your further conversations with your client, if you're counseled, whether internal or external counsel, find out what your client's real interests are, because they lead to quick resolution. Now let's look at interests and positions in terms of definitions. Now, the interest, remember, is what is beneath. They are the things the parties need to protect. They are their needs, their real needs. We'll look at further examples. at least one or two further examples so that we can run this home and get this a lot clearer. That the things the parties need to protect, those are the interests. Positions are the stands taken by parties on particular issues. So you see the next line, they say their needs are different from rights, or positions, they are different from rights. They are actual needs. So you might have a right. A landlord can have a right to his property and wants vacant possession. What is his real need? Is his real need vacant possession? We'll look at that further on. Interests also represent fears and concerns. Positions say, my solution. What are your party's fears? What are your party's concerns? Have you discussed them? As in, tell me what your real concern is. You'll be shocked that the real concern is not what is on the table. A position is my solution. And in mediation, it is not about your solution. There are two parties or three or four or five or six parties on the table. So whatever solution you have, we're not saying dump it in the bin. We're saying there are many solutions on the table. Mediation will then get you to find out how to solve or merge all the solutions so that there is joint interest support or joint interest provision. Interest also refer to underlying motivation. What is that thing beneath the surface that is motivating these parties? Counsel should find that out. You see, it takes a lot of work to do this, and then, but not so much work, just have the conversation. As different from demands, claims, and wants. A want is different from a need. You can want something, but it is not your need. For example, somebody might want to save face, save ego. And the dispute is not about saving face or ego. It might be a joint venture agreement, and someone wants to pack out of the country and move somewhere and says, look, I don't want any part in this joint venture agreement anymore. So I want my stake in this joint venture agreement to be sold out, monetize it and give me this amount. And he refuses to settle on it until that amount is given to him. Meanwhile, you can find out that in that mediation, when you start mediating, because that is now a dispute, because the other party is unable to monetize, the real aim or the real need is not even money. That person is able to move out of the country. His real need is that I want to move. Might not even have money issues as such, but he doesn't want to say this thing to the other party. You know why? Because they've already had relationship issues. Until you resolve those relationship issues, you might not be able to resolve the stance or the positions that have been placed on the table. I hope I'm communicating here. So now let's look further. We've discussed before mediation what you should do. Now during mediation, before mediation, you've seen that you should also identify interest with your parties. But during mediation, these are further questions you can ask to further find out what the interests are. So don't think that because I've already identified or seemingly identified the interest before mediation, then during mediation, I've sorted it out. Sometimes in that conversation with your clients, they haven't told you everything. It is as the mediation unfolds that you then find out a little bit more. So if your party's position has been stated clearly, the kind of question you ask that party is, why is that important to you? Why do you want the joint venture to, why do you want your part in the joint venture monetized? Why do you want that compensation for that property? Why is that important to you? Simple. You begin to hear the real interest. What is the other person's position on the best outcome? What is the best outcome? If you walk away and they don't pay you any money for this case, what would your response be really? Would you be okay with it? Are there alternatives? Now, how do you want the relationship to be when things are settled? Some parties will say, look, I don't care. But it's good to have the conversation. Look, I want to move. I want to have nothing to do with them. While others say, no, I feel he's a good business partner. I feel I want to remain in this relationship. It depends, but ask the questions. How do you want the other person to feel about you? Are you going to still be living in the same space? Let me take a family dispute, for instance. We're now seeing more family disputes where They're not asking for divorce. They're living in the same home, but they're having issues and they bring you to mediation. So this may be a good question. How do you want the other person to feel about you after this case? Now, what made the two of you already agree on? Okay, a common ground could be that we both agree that there should be compensation. So there's already a common ground. You know, it helps, it opens up the door already when you think there's already a common ground. But it's different if you feel there's no common ground. The common ground can be that we both agree that there should be compensation. But to what extent should compensation be made? How much should be paid? Must it be money? Can there be other things that can be done, exchanged? We see all these things every day at the Lagos Multi-Door Courthouse. So these are questions you need to ask, just giving you an idea of how to dig deep before mediation and during the mediation. Be part of the process to keep finding out what are the real interests here. Now, how do you further identify? This is an example. So I'm giving you a background. I said we'll talk about two examples. Let's look at the family dispute, where we have written out here position versus real interest. The petitioner on the table, remember the iceberg. The tip of the iceberg is the position on the table. The petitioner wants dissolution and custody of the daughter. Petitioner, right? Family dispute. The petitioner's real interest is dissolution and custody of the daughter. This is to let you know that the position and the real interest can be the same. So don't go digging deep and you find out there's nothing to dig for. Dig it, find out, ask questions. If the responses remain the same, then that is the person's real interest. The person has put the real interest on the table. Now, but however, let's look at the respondent in this family dispute. The respondent says, I want custody of my daughter. Position on the table, tip of the iceberg. But by the time mediation starts and you get that respondent into those private meetings, the respondent's true interest is revealed because the daughter is young. He can't really take care of the daughter now. He doesn't have a support system. Just give you an example. There are all sorts of stories and all sorts of cases. So the respondent's real interest then is access. He realizes that what I really need, not want, is access. Let's look at another case, landlord and tenant, where you have the claimant, who is the tenant, not the landlord. The claimant is the tenant. And the tenant says, I want payment for improvement on the landlord's property. This is a real life case which I have mediated. This is what the claimant is the one suing, isn't it? And he says, I have developed the property. Now you want me to give you vacant possession. No. Pay me for improvement on the landlord on your property. What is the claimant? This will amaze you. The claimant's real interest by the time we got into mediation was purchase of the property. Not payment, it was purchase of the property. Let's look at the respondent's position. The respondent's position, remember, tip of the iceberg, was vacant possession. That is what they placed on the table. By the time we entered into private meetings, the respondent told me indeed that they wanted to sell, but they didn't want to mention it to the tenant. So, and they also thought the tenant couldn't pay. It will amaze you that by the time it was discovered that the real interests were purchase of property on the part of the claimant and sale of property on the part of the landlord, can you see where there's a merger? Now there was opportunity to resolve. And that particular piece of property somewhere in Apapa was sold for over 80 million naira. They didn't think the claimant could pay. So you now understand why it is crucial before mediation and during mediation to identify the interests of the parties. And I dare say, counsel should identify their own interest in that case. Counsel, what is your interest in the case? Identify it, segregate it as separate from the dispute so that you can deal with it and it does not affect settlement. Let's look at concluding settlement now. Concluding settlement, there's a saying that most people have trouble hearing if they are yelled at, pointed at, insulted, ridiculed, threatened, or otherwise presented with an aggressive tone, words, gestures, or conduct. So this is just like a caveat and saying, beware when you go into mediation that these are things that shouldn't be done, whether at the beginning, before mediation, your interactions, during mediation, or at the point of settlement. If you are about to settle and then you do any of these things, you shout or you're aggressive or your gestures show some form of unwillingness to settle or reluctance, it can affect your settlement agreement. And let's look at concluding settlement itself. What is the format of terms of settlement? Terms of settlement really is just an agreement between the parties, where we highlight certain things that are important that you should look out for, both counsel and parties. Proper identification, who are the parties to the suit? What is the background? Simple, whereas this is what happened. Sometimes parties are very particular. They want to put it in there that this was the background so that it sets the history going forward. And then you have, these are the settlement terms you begin to draft. And we say these settlement terms must be very clear. They must be specific, measurable, achievable. If you say you want to pay a certain sum of money in 1 year, 10 million, how do you plan to pay? You can't say the respondent is going to pay 10 million on or before 31st December 2022. How? When? What is the mode? These things are very important. So those settlement terms must be smart. They must be realistic. They must be time-bound. So I'm using the SMART acronym to explain how the settlement terms will play out. Then, of course, there will be standard clauses. So after your, this is just a format, so you have an idea of what your settlement terms will look like. Then you have standard clauses. There are clauses which can be modified, but typically they are standard clauses in a Lagos multi-door courthouse settlement agreement, where confidentiality, which will state that the terms are confidential. If it is a court case, then it probably will be modified to say that the discussions that you have held will be confidential. You know, the mediator is not to be called as witness. It's without prejudice. Future disputes, it will deal with future, what kind of future disputes may arise. It will reference them, that these particular terms of settlement has resolved all claims, all disputes, all so and so, you know, you need to state to what extent. Is it limited or is it complete absolution in terms of settlement terms? And of course, finality of the terms of settlement. These terms of settlement are final. Then of course, signatures and dates, send the right people to sign off. The signatories must possess full authority to sign. Some institutions request, some corporations actually request the multi-door courthouse to have a request for a seal, you know, from the company to be sure that the company is well represented. Now, is the agreement workable? I discussed this already. Are the funds available? So you can't push and say, no, pay 350 million, pay 100 million, pay 2 million, or whatever the sum might be, or provide whatever the agreement might be. Be sure that the funds are available. Who pays to whom, how much? I think I've sorted this out. Timetabling. Our settlement terms will be very clear on timetable. There wouldn't be a table there. We'll pay on or before this date. It will be written, you know, out. Now we say for mental, physical fatigue, be prepared to come for mediation. It's a tasking process. It's a tasking process because a lot of thinking goes into it. So be prepared to have those conversations. If you need to come, we serve at least water and biscuits, at least for legal settlement. But beyond that, if you know you're someone who has sugar issues and you need to sort that out, be prepared with whatever you need to come with. And then if you find out that the day is fast spent, you can take a short date, 2 days. Say, let's come back in 2 days and sort out this remaining part of the terms of settlement. Sometimes we'll push you, like we had a matter that ended at 7 p.m. yesterday. It was a family case. And they already had settlement terms. They couldn't conclude, but it was just one issue left. Sometimes it's better to push to the end. So we just prepare your minds for that. Then we say document the agreement and sign no matter how late in the day, as long as you can come to that agreement, sign off on that day so that that is sorted out. Now, who drafts? We say the mediator takes the active role. So be prepared that the mediator will take the active role, but everyone contributes. Counsel contributes, parties contribute, everyone is working and you're reading it. You're going to read those settlement terms. Be sure it represents what you want. Be sure of the grammar that is used. Check everything out before you sign that agreement. And then parties and counsel, of course, will read through the terms and ascertain if it is accurate. Thank you very much. We'll take questions now, Rose. Thank you very much.
Yes, ma'am. Thank you very much for that instructive presentation. Okay, so we have interactive session now.
You're welcome, Rose. Thank you.
You can take your questions. If you have any question, you can raise your hand. Raise your hand. Have any question?
Hi, Rose. No questions?
No questions.
And none in the chat. I don't see any in the chat. You can, sorry, just you can unmute if you want to. If you have any concerns at all, you can raise your concerns here, and so that we can all discuss them. You might have the answers right here in the room. You never know. So just feel free to make your contributions or questions. If they're not questions, they could be contributions. Thank you.
Rose, it doesn't seem as if there are any questions. So I think we can sit.
Director Ma, can we call someone? Okay, at least.
Hello, good morning. Good morning. Hello, good morning.
Good morning. Good morning.
Yes, my name is Ms. Olale. I'm a State Council Assistant Director. I want to find out, is it possible, is it only matters that are in courts that have been referred to the settlement week, or is it like I have a divorce that we are thinking that they might not settle things, but the woman is not ready to go through a divorce, but she has some things she needs to sort out. Can she just approach the Lagos State Multi-Legal Court? Hello, can you hear me?
Yes,
Did you
ma'am.
get my question?
Yes, I can
Did you
hear
get my question?
Yes, you can approach the multi-door. You can visit us at the office at Ikeja, the High Court of Lagos State, Ikeja Judicial Division, the ADR track office. And then you can also visit our inquiry desk at TBS Lagos. It depends on the location that is favorable to your client.
Thank you very much.
Yeah, thank you, Rose. So, Mrs. Adedayo, or Miss, in addition to what Rose has just said, Mrs. Please, Mrs. Adedayo, in addition to what Rose has just said, we do take cases that are not in the court system. So we call them, if you look at what the director in her slide, she had made reference to walk-in matters, which just means you can walk in from anywhere. You can walk in. So please walk in, feel free, walk into any of the places Rose has mentioned and file your case. It's a very simple process. All you need to bring is fill the forms and attach statement of issues. Nothing like necessarily like a statement of claim, but just say what the issues are in writing and submit. We'll take the process up from there.
Okay. Thank you very much.
Thank
Yeah,
you
you're
very
welcome.
And there's a question on the chat. It says,
So somebody is raising their hand, Rosemary. One, Oliver Ilori. Oliver Ilori is raising his hand. Yes, Mr. Ilori, can you please, yes, can
Yes,
you
good
please
afternoon. Can you, I'm sure, I hope you can hear me. Good afternoon, everybody. My question, there are two questions. The first one is, my understanding is that it's meant to be consent, the meeting or the referral should be by consent of both parties. Where one party is not willing to commit or does not consent to being referred to multi-door, is there anything that can be done to ensure that the party comes? Because if he's not willing to come, then nothing is going to happen. That's the first question. The second one is more of like a comment. I understand that during the mediation session, documents are meant to be made available. I was under the impression that cases that are already in court, because of the front loading, we've already front loaded all our documents, the documents that the parties intend to tender or rely on. Why do we need to bring this bonus of documents again? When I understand that the files from the courts are transferred to the mediation center, LMDA, so for them to look through, get everything ready. Some people may feel that, well, we already have the documents with the courts. We understand that the files have been transferred to the multi-door courthouse. Why should we now start bringing documents? The documents are there. And lastly, when during sessions, I know because I've been there a few times, I know that sometimes the mediators will speak to the parties by themselves, will speak to the solicitors, will also speak to everybody together at the same time with a view to resolving the matters amicably. If at a point in time, a party feels that the mediator is being partial, what are the steps that can be taken? Those are my questions. Thank you.
Thank you, Mr. Ilori.
Okay, thank you very much, Mr. Ilori. So I'm going to ask the Deputy Director to take the question on non-submission. If you said if one of the parties has not submitted, so there are two levels. If it's a court referral and if the working referral. So if it's a court referral, Mrs. Cook, please can you explain? If there's non-submission in court referrals cases and if there's non-submission in working cases. So
thank you,
what do we do?
So if it is a court referral, the provision requires at least one party, where one party is willing to go to the Lagos Multi-Door Courthouse. The judge can make that referral. Now, so in that circumstance, it is rare where the party refuses to come because the judge has made an order. Now, we're not saying it doesn't happen, and I'm still discussing court referrals. Sometimes the parties end up not turning up. But what we're seeing in recent times is that some judges, if you come back to court, we will now send a report to the judge or to the court saying, in this particular case, there was non-submission from so and so party. It will be documented as a process, administrative process, and we send that report to the court. So some judges now, some courts will refer the parties back again and say, look, I'm not continuing with trial. It is a party participatory process. It is important you go back, and of course, on and on, the judge explains the reason why you must come back. And just to buttress that, the reason why the judges will say you should come back is because I'm sure if we can check Donnet and Railtrack, which is a landmark case, and further cases after that, they buttress the fact that you should get to the mediation table. That is the point. Just get to the mediation table, but not necessarily settle. So that is where we say it is still a voluntary process. Just getting you to get to the mediation table is still a voluntary process because we're saying just go and try it out. We're not forcing you to settle. Now, if it is a walk-in, I hope that helps with court referrals. So that system helps the case to ensure that there's submission. So the compelling factor will come from the court. Now, if it's a walk-in, which didn't come from the court, this is a more dicey situation for us. But however, what we do and what our laws permit and our practice direction permits is that where the other party doesn't submit, the ADR judge now summons the other party to attend a session with the ADR judge, who is a sitting judge, of the Lagos State High Court. They are required to make a presentation to the ADR judge why they don't want to submit. So that is the process that's been put in place. And in many cases, that person then submits. So we can't mandate you to come, but the judges are the ones who take it up and then say, look, come to the table and tell us why you don't want to submit. So I hope that is helpful. Thank you.
And Mr. Ilori, does that answer your question? We've explained it in the two different angles. If it's a court referral, what the law says, and if it's a walk-in as well. In the walk-in, you see that there are appointments where the law says the chief judge can appoint ADR judges. Concerning court referral, if just one of the parties indicate interest in alternative dispute resolution, then the judge can mandatorily refer the parties to ADR. So even if they come and some people will come and say, I'm here just because the judge said I should come, I'm not interested. It is now left to the mediator to use his skill and his competence in mediation, his experience to be able to persuade the parties to stay and participate in the mediation process. If it's working and they do not submit, we report to the ADR judge, who is a serving judge of the High Court of Lagos, and who will let them, who will tell them to come and appear before him to give reasons why they have not submitted. So I hope that satisfies the first part of your question. The second question says that you said, why is it necessary to bring documents to mediation when you have already concluded in court? You want to be reminded, first of all, that it is not only court-referred cases that come to mediation. We also have walk-in cases where they just walk in. The matter is not even in court at all. So matters like that, they have to bring in their documentation, anything that is relevant. Even the ones that are in court, if there's any document, maybe for some reason, the file didn't have it. Maybe we don't have the complete file. It's possible. Maybe all the documents, we couldn't photocopy them. Because if there is a file in the court, sometimes the file is very, very fat, very big, fat file. We don't take the cases from the file from the court. We just photocopy the statement of claim and statement of defense. We can't start photocopying everything. So the parties can help by bringing relevant documentation that will help with their mediation. They can help by bringing it. And it's not only court referred, as I've said, we also have walk-ins that have not even been to court at all. It is left to the parties, it's their responsibility to bring their own documentation just to help the mediation process move forward. And if it's court referred, if for some reason we couldn't photocopy all the documents to create our own file, then the parties need to help us and bring the documents. I don't know if that one answers your question. The third question, you talked about partiality, impartiality or something. Am I right? You said, what if the mediator is not partial? I mean, can you remind me?
I was saying, if one of the parties feels that the mediator is being partial.
Yes. Okay.
That what should as a result, the party doesn't want to continue. As a result, yeah. See, what can they do? What are the options available?
One of the things that I said when I was giving my presentation is that the mediator is a neutral person. And neutrality means that first, he doesn't have any interest in the subject matter. Two, he treats the parties equally. He's not judgmental. He treats the parties the same way. And then when we talk about neutrality in mediation, we also mean you are neutral and you must be seen by the parties to be neutral. So if you feel, because we've had many cases I mean, so there are quite a few cases where the parties will come and meet us as the management of LMDC and say that the mediator was partial. When we call the mediator will say, no, I was very neutral. And I say, it is one thing for you to feel that you are neutral. It is one thing for you to be neutral in the eyes of the parties. So it's not you that will say, I'm neutral. I don't know why the parties not. The parties must also feel that you are neutral. Now, if the party feels that the mediator has been compromised or is partial, he must report to the management of the multi-job and say he's not comfortable with this mediator any longer. This mediator is partial. We change the mediator. But of course, we always give mediators opportunity to talk. We always talk to them. We must hear from the other side. We must hear from the mediator. So, but no matter what happens, since one of the parties has indicated that it's not comfortable, then we have to change the mediator. That's what happens. I think that does that answer your question?
Yes, ma'am. I'm grateful. The last question I have, I'm sorry I'm taking everybody's time. The work of a mediator is very important, and I know it can be difficult at times because of the parties could be, they may not be willing and able to participate properly. And the question is, is it possible for lawyers or other members of the public to apply to become a mediator? And if yes, what is the process of becoming one?
That's very simple. It is to become a mediator is open to everybody. It's not only lawyers, it's open to all professions. We welcome, on our panel of neutrals, which consists of mediators, arbitrators, early neutral evaluators. We have lawyers, architects, medical doctors, engineers, accountants, bankers, any member of the public, any professional, you can come. But to become a mediator at the multi-door, you have to go through a process. First of all, you have to be trained as a mediator. So you have to apply for the Lagos Multi-Door Courthouse mediation skills training, which will make you a certified and accredited mediator of the Lagos Multi-Door Courthouse. It's a 6-day intensive training, 6 days, Monday to Saturday. It consists of 2 days of instruction, 2 days of coaching, and 2 days of assessment. If you pass that training, then you go on. If you pass it and you qualify for mentorship,
Rosie, is it from my end?
To apply for mentorship on the panel of veterans. So the deputy director, I don't know if you have any addition. There must have some things I missed out. Can you please? How do you become a mediator?
I adopt all your. I agree. Just to add on that, right now on the panel, what we're looking for is specialty areas. So anyone who is to be added to the panel must be somebody who is bringing a particular skill, which we don't already have. Thank you. So I think we have one more, which we'll answer quickly, and the session will come to an end. And can settlement be done on a matter that judgment has been given on? And we always say mediation is party driven. So if the person who is, let's say, the winner, so to speak, who judgment has been given in favor of, is willing to mediate, why not? You know, of course, a judgment is a judgment, but if the parties, it's party driven, the parties are willing to enter into negotiations even after judgment, because sometimes judgment pushes you to further negotiation. So if you're willing to enter, it's party driven, you can always mediate. Yeah, thank you. Rose, you want to round up, please?
Yes, ma'am. Thank you very much for everyone for attending the session. Thank you very much. You can always visit us at our offices in Ikeja and Lagos for further information or queries. Thank you very much and have a beautiful day. Thank you, Director.
Thank you.
House. Thank you to Deputy Director.
Thank you very much.
Thank you, everyone. Bye.
Very much.
Bye.
Bye-bye.